hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is March 16th, 2023. We do have a quorum. First order of business is moving the minutes of March 14th. Representative Scott, would you move the minutes of March 14th?
Yes, Madam Chair, I will move the minutes of March 14th.
All right. Any discussion to the minutes? All those in favor, please say aye.
Aye.
Opposed? The minutes are approved. All right. First up, we got Representative Frazier. I will move to bring House File 1083 before the committee. Vice Chair Frazier, would you like to move to recommend that 1083 be re-referred to the Human Services Finance Committee?
Yes, Madam Chair, that is my motion.
All right. Got it. Okay. Sorry. We did have this before us before, and so we are moving to reconsider the motion to adopt the DE1 amendment.
Yep.
And Vice Chair Frazier, I believe there's a, I'm aware. I'm just trying to make sure everybody understands what's happening. So we're moving to reconsider the motion to adopt the DE1 amendment. All those in favor, please say aye.
Aye.
All opposed? The motion prevails. Vice Chair Frazier, now would you like to move to adopt the DE1? And then I understand you're going to tell us a little bit about an amendment to the DE1.
Yes, Madam Chair.
Go ahead.
Thank you. So this should go pretty quickly. What we had, and I mentioned this in the last presentation, we had some conversations with DHS. This is really just some changes to allow for DHS to receive notice of these expungements in the process that they would like to. They do it in a similar process in other areas, in other statutes. So we made that change specifically for DHS, and that's why we're back here.
All right. So you are moving the A2 amendment to the DE1.
That is correct.
Got it. Any discussion to the A2 amendment to the DE1? All right. All those in favor, please say aye.
Aye.
Opposed? Motion prevails. Now on to the DE1 as amended. Vice Chair Frazier, would you like to renew your motion to adopt the DE1 as amended? All those in favor, please say aye.
Aye.
Opposed? The motion prevails. All right. Now, 1083 as amended is in front of us. Please go ahead, Vice Chair Frazier.
Thank you, Madam Chair. And as discussed before, nothing has changed in the bill as I presented before. This really has to do with identity theft or mistaken identity and allowing for automatic expungement to ensure that we put folks back in the position that they were before the theft or the mistaken identity took place.
All right. Any discussion? All right. Anything further you want to add before we move this one?
No, I again thank Rep. Johnson for signing on to the bill. As I mentioned before, I think for many of us, anecdotally, we know someone that has gone through this situation or we've gone through it ourselves. And I think this is something that's been in the works for a while, and I'm hoping we can get it done this year.
All right, sounds good. Vice Chair Frazier renews the motion to recommend that House File 1083 as amended be referred to the Human Services Finance Committee. All those in favor, please say aye. Aye. Opposed? The motion prevails. Thank you, Representative Frazier. All right, next up, we've got House File 10, Representative Lislegard. I will move to recommend that House File 10 be referred to the Ways and Means Committee. Representative Lislegard, welcome to the committee. Please tell us about your bill.
Well, thank you, Madam Chair and committee members, for the opportunity to present House File 10 with you today. This should be brief, as I believe that there's just one subdivision in the bill that we are discussing before your committee, and that is subdivision 3 falls within the purview, and this is the penalty section. And there are two items of note. First, the penalty provision are standard grants of power that fall within the existing authority of the commissioner. We intentionally plugged our penalties into the existing Chapter 177 authority. The DE amendment adopted in labor on Tuesday did make some changes to this language, but those changes are only clarifying, not substantive. The second, the DE amendment dropped the private right of action provision, which was the result of negotiations between the parties involved. And Madam Chair, I will tell you that it is nice to see when they come together and they negotiate like that and the bill becomes better. But with that, I do have my phone a friend here who's an attorney, since I'm in your committee. They can walk through the bill and answer any legal technical questions you may or the committee may have.
All right, thank you. Welcome to the committee. Please introduce yourself and proceed. And as Representative Lislegard noted, this bill is before us because of the penalties section in Section 2, Subdivision 3. So please go ahead.
Good morning, Madam Chair, members of the committee. I'm Brendan Cummins, attorney for the Minnesota State Building and Construction Trades Council and the Minnesota Pipe Trades Association. I'm here in support of House File 10, and I will address the enforcement provisions. The bill provides for the Commissioner of Labor and Industry to enforce the law by issuing civil fines ranging from $5,000 to $10,000 per violation following a complaint and investigation. As you know, fines issued by the Commissioner are a standard way of enforcing labor and employment laws under Minnesota statutes, particularly where there's no private right of action or where it's difficult to calculate actual damages. Examples of other laws that provide for fines for enforcement include duty to maintain payroll records, failure to submit records to the Commissioner upon request, failure to post notice of wage and hour rights, or repeated or willful violations of Minnesota employment laws. The bill would make clear that all parties who are responsible for complying with the law would be held accountable for violations. Specifically, not only owners and operators of petroleum refineries, but also contractors and subcontractors would be subject to civil fines if they violate the law. In addition, Section 1 of the bill would provide for compliance orders to be issued by the Commissioner as with other employment laws. Now, I would also note, Madam Chair, members of the committee, that Marathon Petroleum has submitted public testimony in multiple committees, including this one, making claims that House File 10 is supposedly preempted by both the National Labor Relations Act and Employee Retirement Income Security Act. Those claims misstate both the relevant statutes and decisional authority. Regarding NLRA preemption, registered apprenticeship is not a union versus non-union issue. The state and federal regulations cited by Marathon only provide for union input about registration of an apprenticeship program when a union actually represents the employees who are being trained. The requirement of union input does not apply to non-union employees, and in fact, non-union apprenticeship programs are registered in Minnesota. The Associated Builders and Contractors, a non-union advocacy group, sponsors a state registered apprenticeship program, for example. Marathon's argument regarding ERISA preemption misses the mark because this bill would not dictate the choices available to employee benefit plans. The Eighth Circuit case cited by Marathon regarding sprinkler fitter licensing does not apply here. The court explained in that case, and I quote, "Because the Minnesota statute and rules do not offer the choice of compliance with either state or federal standards, but instead mandate adherence to the state apprenticeship standards, they are preempted under ERISA." In contrast, House File 10 would allow the flexibility for apprenticeship training programs to be registered in Minnesota with the federal government and even in other states, so it would not be preempted by ERISA. In fact, House File 10 also offers considerably more flexibility than did the sprinkler fitter licensing statute because it only applies to oil refineries, 2 job sites in Minnesota, not to work throughout the state of Minnesota. Therefore, this bill would not dictate the choices or standards available for apprenticeship programs in Minnesota and is not preempted under ERISA. None of the other similar laws passed in other states, New Jersey, Washington, or California, has been successfully challenged. Therefore, Marathon's attempt to cast doubt on the legality of the bill is not supported by the law. Thank you.
All right, thank you for your testimony. I know we've got a Deputy Commissioner on deck if needed. Are there any members of the public wishing to testify on this bill? Not seeing any, we'll move on to member discussion. Representative Niska.
Thank you, Madam Chair, and Representative Lislegard and Mr. Cummins. I appreciate where this is coming from. My question really has to do with how the compliance order structure and the penalties provision fits together. And specifically, I'm curious as to what level of discretion the Department of Labor and Industry Commissioner has in assigning penalties. And so we're pushing this all through the compliance order process where normally we give the department a lot of discretion. But I was struck by the use of multiple uses of the word shall in the penalties provision that we're looking at. So for example, on page 4, line 24, it says the Commissioner of Labor and Industry shall fine an owner or operator, contractor or subcontractor not less than $5,000 nor more than $10,000 for each violation. So I'm wondering are we still giving the Dolly Commissioner in this context any meaningful discretion to consider whether there are circumstances that might warrant not issuing some sort of a penalty in that circumstance?
Mr. Cummins.
Thank you, Madam Chair. The penalties or the fines are mandatory, and that's deliberate so that there's a clear consequence, a clear and predictable consequence for a violation. The commissioner would have to find a violation, would have to investigate. You ask whether it's inevitable that there would be a fine imposed. No, there's exemptions, for example, in the statute already built in for emergency circumstances, for circumstances when the qualifying labor is not available through a referral procedure. So it's not inevitable that fines would be imposed. But if the commissioner were to investigate, find a violation, there will be a consequence. That's very clear here. There's a strong intent for there to be a predictable consequence. The amount of the fine would be flexible. The commissioner would have discretion and is required to consider the size of the violator's business and the gravity of the violation, as is typical under Minnesota statutes. So there is flexibility in the amount, but there is a strong intent to have a clear consequence.
Representative Niska.
Thank you, Madam Chair, and I appreciate that answer, Mr. Cummins. You listed a bunch of other examples that you were analogizing this to, and I didn't catch them all or have a chance to review those provisions. I think one of them was duty to maintain payroll records, but you listed several of them, and I didn't get them all. But do any of those have the similar kind of shall issue a penalty of not less than a certain dollar amount, or would this be an outlier in the way that we're setting up our penalty provisions?
Mr. Cummins.
Madam Chair, members of the committee, my recollection is that the repeated or willful violations provision has a shall, and the rest have may. I think that the norm is may, but there is a shall.
Representative Niska.
That was all I had. Thank you.
All right. Any further discussion to the bills? Representative Scott.
Thank you, Madam Chair, and Representative Lislegard, and to the testifier as well. Just a couple of questions. I had one on, I think it's new language that was engrossed on page 3.3. No, I'm sorry. It's 2.28 through 2.32. And the section is relating to grandfathering in with 5 years of experience. And if a person has completed training identified as necessary by the registered apprenticeship training program for the employee to become a qualified worker. So my question is, does this apply to merit workers too, or just who does this apply to?
And Representative Scott, the question before us is whether the penalty section is appropriate in application. I'll allow you to answer this, but we really do need to stick to what's in our jurisdiction. Mr. Cummins.
Madam Chair, members of the committee, this provision applies to all workers at a refinery who are in an apprenticeable occupation in the building and construction trades. And I think when you use the word merit, you were referring to non-union. I wouldn't use that term for the non-union, but I think that's what your intent was. This would apply to any worker, whether union or non-union. And as I mentioned before, the non-union are eligible to register for apprenticeship programs in Minnesota.
Representative Scott.
Thank you, Madam Chair. And what I'm trying to get at here is, this is directly related. I want clarification on the language so that we know who's going to be penalized and who's not with, according to the sections of the bill that we are supposed to have purview over. So does this mean then if an employer kept on a merit worker that's been there 5 years, would they be penalized for doing that if they met these other criteria?
Mr. Cummins.
Madam Chair, members of the committee, an employer is not going to be penalized if they meet the requirements of the statute. And anyone who's participating in a registered apprenticeship program under any of these 4 pathways, any employer that has its employees participating in an apprenticeship program in any of these 4 pathways is not going to be penalized, provided they meet the percentage threshold set forth in the statute, 30%. Starting January 1 of next year, then 45% for the following year, 60% for the following year. So if that worker, the hypothetical worker you're talking about, is among a percentage, say in the first year, 70%, they don't need to fit in any of the apprenticeship pathways. But they would qualify for an apprenticeship pathway, even it being non-union, if they work for a non-union employer that sponsors an apprenticeship program. This is not a union, non-union issue, not a merit shop versus non-merit shop issue. I want to be very clear about that. It seems like that's what's driving your concern, and non-union can register an apprenticeship program.
Representative Scott.
Thank you, Madam Chair. I'd like to go on to this 30% threshold for the first year. So if an employer has 8 employees on the job, that 30% of that is 2.4. So is that 2 employees or is that 3 employees? And how, I mean, do they round up or round down?
Mr. Cummins.
Madam Chair, members of the committee, the issue of rounding would be left to the interpretation of the Department of Labor and Industry, and typically rounding is done down if it's below 2.5 and up conventionally in any sort of interpretation. And I would expect they would adopt a reasonable interpretation.
I'm pretty sure that's what my 3rd graders' homework looks like, too, when we do rounding. Representative Scott.
Right, Madam Chair, and I went back to that, too, on that question. I'm like, well, I would round down because that's what I was taught in 3rd grade math class. But, all right, well, thank you for answering those questions. Yeah, I guess I'm finished.
All right. Closing comments, Representative Lislegard.
This is a great bill, and I hope that you can support it.
All right. With that, I will renew my motion that House File 10 be re-referred to the Ways and Means Committee. All those in favor, please say aye.
Aye.
Opposed? No. Motion prevails. Thank you. Next up, we've got Representative Nelson. House File 1522. I will move to recommend that House File 1522 be referred to the Labor and Industry Finance and Policy Committee. And just reminding folks, there are a couple data provisions, and that's why this is under our jurisdiction. So Representative Nelson, please tell us about your bill.
Madam Chair, House File 1522 is just a housekeeping upgrade update of some of our OSHA, the OSHA portion of law. The 2 provisions I believe we're talking about here would be Section 2 and Section 3. It's before us. Section 2, it's just a minor tweak to the portion of who can be subpoenaed. And what it's just changing is from it's adding former employees of the Department of Labor to not be allowed to be subpoenaed in cases. And the other piece has to do with Section 3 has to do with classification of data that after 20 days after the citation's been given to an employer, the information is public. This applies to union contractors currently. This would make sure it applies to non-union contractors, so everyone's treated the same. And I have Mr. Kruger here from the department that he can explain the bill better, maybe answer questions that way.
All right, Director Kruger, welcome to the committee. Please introduce yourself and go ahead with your testimony.
Good morning. My name is James Kruger, and I'm the Director of the Occupational Safety and Health Division, Compliance with the Department of Labor and Industry. Thank you for the opportunity to testify in support of House File 1522. This bill before you today makes 2 policy and technical changes that are under our jurisdiction of the Judiciary Committee. First, the bill clarifies that both current and former employees are not subject to subpoena for purposes of inquiry into occupational safety and health inspections. The second bill improves transparency of Minnesota OSHA citations. The change would classify written citation data as public 20 days after the employer has received the citation. This proposal would allow MNOSHA to provide timely information to the public and stakeholders about its enforcement. Additionally, this legislation would align MNOSHA with other programs across the country. Each of these changes make an important update to MnOSHA policy. These changes support the workers, the employers, and the occupational safety and health professionals whose shared goal is to move Minnesota forward as a leader in workplace safety and health. Thank you for the opportunity to speak in support of House File 1522, and I would be happy to stand for any questions.
All right. Anyone from the public wishing to testify? Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair, members of the committee. For the record, my name is John Beshe. I'm with Associated Builders and Contractors of Minnesota. ABC is opposed to several of the provisions in this bill. However, as it relates to this committee's jurisdiction, I'll focus my comments specifically on Section 3, which addresses the classification of the MnOSHA citation data. Current law and practice already make MnOSHA citation records timely and readily available through FEDRA OSHA's website after a matter is closed by the department. Anyone can search the citations listed by employer, project zip code, data range, and more. From there, any member of the public can see if an investigation is open or closed, the type of penalty or fine that may have been issued, as well as the union affiliation or lack of for the contractor at issue. The publication in this bill of the nature of the investigation before claims are fully adjudicated will create an appearance of guilty until proven innocent for the named contractor. There are many times when a citation is issued and a contractor appeals that citation. When that happens and the contractor is successful, the penalty or fine may be reduced or not levied at all. ABC members have been subject to dozens of OSHA investigations based on anonymous complaints that were later determined to be without merit. However, the appeals process takes time, sometimes even a couple of years. If this section is enacted, we're concerned that the publicly available information could be used to engage in smear campaigns against contractors, even if the allegations in the citation haven't been formally adjudicated or even subsequently dropped by the department. In MnOSHA citation matters, the individual is essentially guilty until proven innocent, and MnOSHA does not have to produce its original records with the evidence of the violation until after the notice of contest is filed and the judge sets discovery. This makes it extremely difficult for employers to determine whether the complaints against them have merit and to adequately respond to the allegations. If these details are going to be made public 20 days after the employer receives the citation, we believe that MnOSHA should also be required to provide the accused with the copies of any documents that detail evidence of the violation upon issuance of the citation. In closing, we urge the committee to vote no on House File 1522. Thank you again, Madam Chair, members of the committee, for the opportunity to testify.
Thank you. Anyone else from the public wishing to testify? All right, not seeing any. We'll move on to member discussion. Representative Scott.
Thank you, Madam Chair. Representative Nelson, what's your rebuttal to this whole due process issue where you're putting up an accusation that hasn't been proven yet for public consumption?
Representative Nelson.
Madam Chair and Representative Scott, when they're saying that it's 20 days after the citation is issued, if the OSHA comes out and finds nothing, there is no citation issued. So if they do a citation, it's something that they found that was where OSHA rules were violated. And the public should know that, the other people should know that, people going to work for a contractor or an employer should know that if the employer is working in an unsafe fashion.
Representative Scott.
Thank you, Madam Chair. And this isn't my area of expertise, obviously, these work sites, but what if OSHA can't get out there within the 20 days?
Representative Nelson.
Again, there is no citation issued until they find something wrong. If OSHA doesn't get out there for 20 days, and again, this is when they're notified of the citation, the employer's notified of the citation. So that means OSHA would have gone out, inspected the site, filed the citation, would have gone to the employer. So that's when the 20 days starts, not 20 days when someone calls in a complaint and says, XYZ is violating this law or this rule, they're doing something unsafe. If OSHA doesn't get out there for 20, 30 days, and they find nothing, there's no citation issued.
Representative Scott.
Thank you, Madam Chair. And so what do you make of the gentleman from ABC, I believe it was, said that there's a lot of unfounded accusations towards employers, and in the end, they're found out to be frivolous. How do we how does this bill address that?
Well, again,
Representative Nelson.
thank you, Madam Chair. Again, Representative Scott, if there's an accusation made and OSHA comes out and finds nothing, no citation is issued, nothing is public. So basically what this is doing is putting the non-union fair shop contractors, employers on the same vein as the union employers, that these are issued public within that 20 days, they're right away, as opposed to in the non-union sites.
Representative Scott.
Thank you, Madam Chair. My final question is, I can't think of a place, and maybe there is, in Chapter 13, where kind of investigative data is ever made public until the investigation is over with completely. Because, and one of the examples that came to my mind was the Judiciary Standards Board, and I'm probably getting the title of that entity wrong, but it's where people can go and can complain about judges. And none of those accusations are made public until after there's been a fair due process. And then they're made public if there is a finding. And I feel like this is getting the cart before the horse in an unfair way compared to the rest of the way that statute really kind of works, is that you don't put anything out there until it's been proven and the process has been gone through. So I'm afraid I can't support this today. Thank you for the line of questioning.
Representative Nelson, any further comment? Yeah, this maybe it's a different bill if we want to get rid of unfair complaints on Yelp and Google. That seems like a different thing to deal with. Any further discussion to the bill? Representative Niska.
Thank you, Madam Chair. And Representative Nelson, I have actually dealt with licensing orders through Dolly, and what you left out of your description of the process is that after that OSHA has brought a citation, there are further steps before that due process that a contractor or a company can go through, an employer can go through, before a penalty is actually brought against them. And so my question to you is, in those situations in which those further steps are taken and an employer is able to successfully challenge that, where do they go for their reputation back?
Representative Nelson.
Thank you, Madam Chair, and Representative Niska. Again, there are some contractors now that these complaints are already issued within that 20-day. So this is just putting them on a level playing field, all employers on a level playing field, so that if there's a citation, again, if there's a citation ordered, it's within 20 days, it's being received by the employer contractor, they're made public, so that public knows what's going on and that there's been a problem. They also publish the results if there's an investigation and nothing is found, or the problem is corrected. And there's other issues, ways they can go about this, but that's basically, it's putting everybody in a level playing field.
Follow-up, Representative Niska.
Thank you, Madam Chair. And my only final comment is that, again, these are allegations by an administrative agency. They're not adjudications of an actual problem existing. And so I think that we're presuming guilt in a situation in which guilt has not really been proven through a true due process. And that's my concern with the bill. Thank you.
Thank you, Representative Niska. And I think maybe want to be careful in calling a citation from a department an allegation, because there is some level of finding, the same as when we get a speeding ticket or a parking ticket. It's also a citation too. Follow-up, Representative Nelson.
I didn't hear a question there, but if you want, I can wrap up the bill. And
That'd be great.
Anyway, again, this is just minor technical changes to the OSHA law, upgrading our standard, upgrading the laws, and I think you said it's going back to labor.
Yes.
I think that's so. I hope members hope for a yes vote.
All right, thank you. With that, I will renew my motion to recommend that House File 1522 be re-referred to the Labor and Industry, Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed? No. The motion prevails. Thank you, Representative Nelson.
Thank you, members. Thank you.
Representative Agbaje. And I was in such a hurry to get through all our bills. I did bring coffee for members. Yep, no, yeah, exactly. Caffeine does stay in your system for up to 10 hours, so it'll hopefully.
To put it in.
There are some cups over on this side, but I know some of you already bring your mugs, so, but it's there for members. Welcome to the committee, Representative Agbaje. I will move to recommend that House File 908 be referred to the Ways and Means Committee. Please go ahead and tell us about your bill.
Thank you, Madam Chair and members of the committee. House File 908 is a bill to ensure that our nursing home workers are providing the best service for Minnesotans who are living in nursing homes. This is also a bill to help address the staffing shortage crisis we're seeing in nursing homes since the start of the pandemic. Unfortunately, we aren't going to be able to solve that crisis and give our nursing home residents the care they deserve until we address the crisis of compensation for the frontline essential workers who keep nursing homes running. This bill aims to do that by creating a nursing home workforce standards board. This is an old idea dating back to the Great Depression that's getting new life around the country as a way of bringing workers and employers in specific industry along with their regulators to hopefully work together and improve both wages and working conditions for those that are caring for our loved ones. This bill would create a 9-member board appointed to stagger terms by the governor as required for a rulemaking body. Those members would include 3 employer representatives, 3 worker representatives, along with the commissioners from 3 agencies, which are the Department of Health, charged with regulating nursing homes, Department of Human Services, that funds nursing homes, and Department of Labor and Industry, which address labor standards. The Nursing Home Workforce Standards Board would be charged with investigating market conditions that would require direct engagement of workers and employers so that the board has an appropriate information to set minimum standards for wages and working conditions through rulemaking. And these rules are meant to be reasonably necessary and appropriate to protect the health and welfare of nursing home workers. So I'll use the rest of my time to focus on the areas of the bill that fall under the jurisdiction of this committee. So under sections 2 and 3 of the bill, the labor standards established by the board would be enforced through the Department of Labor and Industry's existing authority. And section 2 allows this through the compliance orders. In section 3, this again is outlined to give DLI the power to enforce the labor standards promulgated by this board. This bill also gives a private cause of action modeled directly on the one already in place in the state's Fair Labor Standards Act, which you can find at Minnesota Statute Section 177.27. And it's reiterated in this new chapter of law should this go into law. To ensure that workers are aware of the board's process and how to participate, as well as the standards set by the board and their rights, duties, and obligations, should this become law, the Nursing Home Workforce Standards Board will be required to create a training curriculum that will be delivered by worker organizations certified by the board once every 2 years, and employers will need to provide a notice developed by the board to their employees in whatever manner they already use to provide other work-related notices. And finally, this bill ensures that workers are protected from retaliation for exercising their rights under this bill, including participating in board proceedings and trainings. We have an obligation to provide for the care of our seniors, but unless we address the crisis of wages and working conditions in our nursing homes, we will never have the workforce needed to provide that care. Creating a Nursing Home Workforce Standards Board is a proven way to address that crisis and give essential workers, those who we spent the last 2 or more years praising, a voice in helping to determine those minimum standards in partnership with their employers. And with that, I think there might be some testifiers. Otherwise, there's also letters of support in your packet as well.
All right, thank you. I did have a couple of people signed up. I have Toby Pearson and Aaron Hubbard. Welcome to the committee. Are you testifying together? Okay. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair, members of the committee. For the record, my name is Erin Hubert with Leading Age, and I'm here on behalf of the Long-Term Care Imperative. My colleague, Toby Pearson, will go after I wrap up. First, I'd like to acknowledge that since we've had our first hearing in labor about a month ago, we've met a number of times both with the bill author and with the proponents to try to resolve some of these underlying concerns. We continue to talk, so hopefully we'll see some more progress, but we are testifying in opposition today. I think I'll be very brief about my general comments and then turn things over to Mr. Pearson to get to some of the specifics within the jurisdiction of this committee. But I think we would be abdicating our responsibility on behalf of nursing homes to not underscore very briefly the challenges that we have with this bill. First, the bill does nothing to actually provide funding for nursing home workers, not their wages, not their benefits, and not the number of staff that we have. Furthermore, there's nothing in the bill that would require or ensure that the standards set by the board could be met by our 350 nursing homes and their 350 rates. So critically, there's nothing in the bill that offers remedy or recourse if the nursing home is unable to financially meet the standards set by the board that are then going to be enforced under the sections of this committee. Second, the bill will force many nursing homes to cover new expenses by making a reduction somewhere else in their budget. So while the proponents have argued that this is really about staffing and workplace conditions, we see that it will very quickly have an impact on the health and safety of our residents as well. Third, as constructed, this 9-person board has no legislative oversight since all appointments are made by the governor and has no legislative appointees. The board is also given expedited rulemaking authority with preemption of other state agency rules with very limited exceptions. So I will turn it over to Mr. Pearson, who can get to the specifics on our concerns for this committee.
Welcome to the committee. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. My name is Toby Pearson with Care Providers of Minnesota on behalf of the Long-Term Care Imperative today. To pick up where my colleague left off, one example that we were trying to work through with the advocates as well as the author is the board setting staffing requirements that a facility is then unable to attain and then therefore has to decrease staffing or numbers of beds. And this particularly wraps into the subdivision 3, where you now have a private right of action to go against these somewhat vague staffing, new staffing relations. So what we would like to see is the language that would require the Commissioner of Department of Labor Industry to review prior to those. So it would be, the idea here is that the current language has undefined language violations of the statute, such as or any applicable minimum nursing home employment standards or local minimum nursing home employment standards. And they would go directly to the district court on a violation of these vague standards. So this would pose a problem for the parties as they would likely have to prove what those standards are without actually knowing what those standards may be. So we think this would be best reviewed by the Department of Labor and Industry or an administrative law judge prior to during a contested case type hearing setting rather than going straight to district court. To go right to district court could be costly upon such allegations, both the employer and the employee. We do recognize that the employee already has the right to go to district under the Fair Labor Standards Act. We are not objecting to that part of the language. So for your consideration, we would request that we change that language. We have relayed this to the advocates, and we are hopeful that we are able to work through this as we move forward. Again, we have regular meetings with them, and we hope that with the author's help, we can come to an agreement and have a bill at the end of the day that we can all live with. Thank you.
All right. Is there anyone else from the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Niska.
Thank you, Madam Chair, and Representative Agbaje. I was interested in understanding a little bit more about how the private right of action works in particular. And I understand that this language is analogous to what we already have in the FLSA, and maybe the answer to that, my question lies somewhere in the FLSA case law. But I noticed that on page 13, line 16, it doesn't require that the nursing home workers be injured, or it doesn't say the word injured there, but on line 17, it does use the word redress. And so I'm curious whether that imposes some requirement that a nursing home worker actually suffer a personal injury, or suffer some sort of injury themselves in order to bring an action under this provision.
Representative Agbaje.
Thank you, Madam Chair. Thank you, Representative Niska. My understanding of the civil right of action is kind of based on if there are violations of any of the standards that would be promulgated by the Workforce Standards Board, should that be created. So I don't think it necessarily pertains to a personal injury or an injury to the physical body, but just if there's a violation of the rules that have been done by the board, then you would have a right of action to sue on that.
Representative Niska.
Thank you, Madam Chair. And Representative Agbaje, I understand that I used kind of a confusing term there. I didn't mean personal injury as in a bodily injury. I meant an injury that that nursing home worker actually personally suffers, rather than just that they work at a nursing home that violated something technically. So my reading of the word redress, or one interpretation of the word redress, might imply that they actually personally have to suffer an injury. And so I was wondering if that's the way that we are limiting or defining who can sue, as opposed to just any nursing home worker at all, even one that didn't suffer any sort of personal effect from the violation.
Representative Agbaje.
Thank you, Madam Chair. Thank you, Representative Niska. Again, this is based exactly on the Fair Labor Standards Act. So if a individual worker can say that rules were violated, then the same would apply here.
Representative Niska.
Thank you, Madam Chair. And Representative Agbaje, I was hoping for a little bit more clarity on that question, but I do have another question related to the testimony about, and a concern about the way that nursing homes economically are able to pay wages and, maintain staffing requirements. And so I don't see anywhere in here any way in which the nursing home might be able to defend against a lawsuit by saying that they haven't been given adequate resources by the state to meet the nursing home standard, the standards that are being set. Would there be any sort of defense by the employer to say, we're funded by the state and the state hasn't given us sufficient funding to meet the standards that are being set?
Representative Agbaje, please go ahead.
Thank you, Madam Chair and Representative Niska. So this, the way that the funding and the structure is sort of outside this jurisdiction, but I will explain a little bit further. So the purpose is that the board would set these rules and standards, and it's based on kind of the funding that has already been forecasted to go to nursing homes. That's based on what the federal government and the state government provides. Should the board make a rule that surpasses what is available in that forecast, then it would go back to the legislature to have to approve that rule. The rule would not go into effect until the legislature says yes or no. So that's actually an area where you can get legislative oversight. And so that, there's still conversations around that, but that is the general premise of how the board would work. So if a rule would not go into effect, so I don't think there would be a cause of action for an employer, because they would not actually need to implement anything until the legislature gave the approval, if the board went further than where they were able to go.
Representative Niska. All right, Representative Scott.
Thank you, Madam Chair. And I just wanted to kind of go down the same road a little bit as Representative Niska's line of questioning on the redress and the civil cause of action. So if, let's say a nursing home doesn't have the proper staff level of CNAs for a day. So could someone that's in the kitchen being a cook bring a suit under this language?
Representative Agbaje.
Thank you, Madam Chair. Thank you, Representative Scott. I'm not entirely sure. I mean, I think that the issue would be about whatever that rule was specific to. So if it was specific to CNAs, it would seem that CNAs would be the ones who would be harmed by not following those rules. So I'm not entirely sure that other workers would have the same type of harm as the CNAs would.
Representative Scott.
Thanks, Madam Chair. I'm wondering if House Research could take a stab at that. with the existing language here.
Oh, Madam Chair, also one more thing to add.
Representative Agbaje.
Thank you, Madam Chair. The board also is mostly focused on like wages for the workers and kind of conditions around those, but they are not, they don't have authority over like work, like staffing conditions and kind of like how staff treats the residents and things like that. It's really strictly around the cost and labor issues particular to nursing home workers.
Aaron.
Chair and members, Mary Davis from the House Research Department. The section that deals with enforcement that I understand in this bill is Section 3. It's on page 2, and it refers to an existing section of statute where the commissioner can look at violations, and it highlights 181.213 and 181.215. So those would be the sections that I believe they would be working on enforcement. And I don't know if somebody's here from labor who could elaborate as to how they do that.
Representative Agbaje. I don't know if we have an answer to that, but
I don't think so, but we can follow up with you, Representative Scott.
Oh, thank you.
Representative Scott.
Thank you, Madam Chair. So I look at this bill and I think, number one, why are we as a legislature abdicating more of our authority to a gubernatorial appointed board when we have agencies now that can do this enforcement? My other issue is really just how this industry is already on the verge of collapse. We already have complete wings of nursing homes shut down because there aren't enough people working there. They can't find enough people working there. And the industry is already heavily regulated. And I just feel like this is just a pouring on and a piling on to this industry that's really struggling, and this industry that's so vital right now with our demographics of an aging population. And I certainly don't want it to collapse, and I don't want to be a part of anything that would cause it for that to speed up or that to happen. Madam Chair, my final question is this bill going to state gov, or what's the next stop for this?
Representative Agbaje, we're sending it to Ways and Means, but I know we're on the second engrossment, so I know it's made a couple stops already. Representative Agbaje.
Thank you, Madam Chair. Thank you, Representative Scott. Yes, we have been in State Gov, and we have been in Labor, and now we're in Judiciary and then Ways and Means.
Okay, thank you. Yeah, thank you, Madam Chair. And I just urge members to really think about what this bill is doing to an already hurting industry. And it might be different, maybe, if we'd already seen a bill pass that funds our nursing homes to the extent that they need to be funded. But that's not the case here, so I would encourage a no vote. Thank you, and I would ask for a roll call.
All right. We got one more person on the list, Representative Johnson.
Chair Becker-Finn, Representative Agbaje, I understand what you're trying to do, but I've learned in my years on the civil law side of this, you have to look for the unintended consequences of a bill. And looking at the unintended consequences on this bill, I don't see any good. Our nursing homes and our assisted living facilities are in dire need. I don't know if any of you have ever tried to find a bed for one of your relatives. I'm at 19 months waiting for a bed, and we have applications in multiple facilities for a relative. This is going to make this worse. They're shorthanded of employees now. As has been mentioned, numerous wings and numerous facilities are closed because of lack of staff. And it's not that and most of them are paid fairly decent, a livable wage, but we don't have people working. They're sitting in their basements watching TV, getting a check from the government. Putting more restrictions on the, not oversight, more authority, almost like a dictatorship, telling these nursing homes what to do when they're struggling, trying to find ways to save money to get staff. He's going to put them out of business. I think, if I remember correctly, about 2 weeks ago, I heard that 2 more were closing in greater Minnesota because they can't get staff. And more burdensome regulations by bureaucrats that don't have to come to this body to get stuff approved makes it worse. Unfortunately, this body gave up the rulemaking authority and oversight of that decades ago, which we need to bring back before any rules go into effect. This body should approve them. But unfortunately, we gave that away, and we have to take that back. I'm concerned that with the unintended consequences of this bill, everybody appointed by the governor,
And Representative Johnson.
it's time to
Representative
abstain on this
Johnson,
bill.
I'm just going to remind you, we're talking about the liability provisions is what we're discussing here. I assume the appointment by the governor and all that was thoroughly vetted in previous committee stops. I'm getting nods from the author. Go ahead, Representative Johnson. Okay. Representative Scott.
Thank you, Madam Chair. And unless there's a clone of this bill traveling, this bill has not been to state gov, and it is setting up a new board, so it would need to go there.
Representative Agbaje.
So, sorry, I misspoke on that. It is sorry, let me just read the bill path that we have. So we started in labor, we went to human services, and then now we're in judiciary. We had approached state gov. I believe state gov had waived, but we can approach them again to see if they need to hear it.
All right. Anything further, Representative Scott?
I would move that it goes to state gov. I'll make that motion, Madam Chair, that we re-refer this House File 908 to state gov.
Okay, and are you requesting a roll call on that motion?
Sure.
Okay, one more person on the list, and then we'll move to that vote. Representative Finke.
Thank you, Chair Becker-Finn and Representative Agbaje for the bill. I just wanted to follow up on the question that Representative Scott asked earlier. I know we're going to get an answer to the question about whether or not a cook is eligible to make a violation report. And if the answer to that is that no, I would like to make sure that if there's a violation of the Fair Labor Standards practices that is happening at a nursing home, anyone should be able to report that. So it shouldn't be, cooks are just as eligible to make reports about fair labor and standards practices as anybody else. Thank you.
Madam
All
Chair.
right. Representative Scott.
Thank you. Just for clarification, I wasn't saying they couldn't make a claim. I'm just saying if it was a different group of people, let's say that it was the CNAs that were understaffed, and let's say a CNA made the allegation, would then, in a class action piece, would that be drawn in the cooks and every employee on the premises? So that was my clarification. Sorry for the confusion.
Okay. And I imagine if there's understaffing, everybody in that building is impacted. Moving on to the vote. So on the motion to refer House File 908 to the State Government Committee, the clerk will take the roll.
Chair Becker-Finn.
No.
Vice Chair Frazier.
No.
Minority Lead Scott.
Yes.
Representative Carroll.
No.
Representative Curran.
No.
Representative Feist.
No.
Representative Finke.
No.
Representative Frederick.
No.
Representative Grossel. Representative Johnson.
Yes.
Representative Moeller.
No.
Representative Niska.
Yes.
Representative Weens.
Yes.
4 ayes, 8 nays.
All right, the motion does not prevail. All right, Representative Agbaje, closing comments. I will again move that we refer 908 to the Ways and Means Committee, but Representative Agbaje, final word.
Thank you, Madam Chair. Thank you, committee members. Again, the purpose of this bill is to support workers, to ensure that as an industry, they have a voice along with their employers and their regulators as to what the standards around costs and wages around those areas around labor will be. And we also are looking forward to ensuring that they continue to be able to fight for their rights should they be violated. So thank you again for the committee's time, and I look forward to your support.
All right, Representative Scott, were you also requesting a roll call on the underlying bill, or, okay. All right, so I will renew my motion that House File 908 be re-referred to the Ways and Means Committee. The clerk will take the roll.
Chair Becker Finn.
Aye.
Vice Chair Frazier.
Aye.
Minority Lead Scott.
No.
Representative Carroll.
Aye.
Representative Curran.
Aye.
Representative Feist. Representative Finke.
Aye.
Representative Frederick.
Aye.
Representative Grossel. Representative Johnson.
No.
Representative Moeller.
Aye.
Representative Niska.
No.
Representative Weens.
No.
8 ayes, 4 nays.
8 ayes and 4 nays, the motion prevails. Sorry, Chair Moeller is losing her voice, so thank you for the comedic timing. Representative Feist, did you want to do House File 1019 first? Okay. Representative Feist, I believe your motion is to recommend that House File 1019 be placed on the general register. Representative Feist, is that your motion?
Yes, Madam Chair, that is my motion.
All right, and then I understand you have an A1 amendment that will align the House language with the Senate language. Would you like to move that amendment?
Madam Chair, I would. Can I explain it very briefly?
Yes, that'd be great.
Yep, thank you, Madam Chair. I just wanted to explain that this is the result of conversations with stakeholders. We are extending or shortening the statute of limitation and feel comfortable with that. So I just wanted to make it clear that this is a substantive, not just a technical amendment.
Appreciate that. Any discussion to the A1 amendment? All those in favor, please say aye. Aye. Opposed? The motion prevails. All right. Representative Feist, the bill is before us as amended. Please tell us about your bill.
Thank you, Madam Chair. Thank you, committee. Madam Chair and members, thank you for considering this important legislation that allows Minnesotans to seek justice. I want to particularly thank my co-authors who are on this committee, Representatives Johnson, Niska, and Chair Becker-Finn. Minnesota is the only state in the union that has a statute that mandates that an injury claim dies with the person and does not survive the benefit for the benefit of your estate. This statute has produced glaring injustices to many families in Minnesota, and it allowed some to escape accountability for wrongful acts. On occasion, an elderly person or someone who has fallen ill that has a valid injury claim will encounter resistance in the resolution of claims or delay in the legal process. Because of the current law, there is a perverse incentive to stall a claim in these situations, which can produce an unfair windfall to the person that caused the harm. In other states, these injury claims are allowed to move forward to a conclusion for the benefits of the family and to pursue justice and accountability for the harm their loved ones have suffered. The legislation allows for a family to recover all the damages a person suffered before death in a wrongful death or injury action, as is the case in other states. This bill will eliminate any benefit for delaying resolution of a claim. The process for pursuing these claims is well settled through the appointment of a trustee under Minnesota statute 573.04. This bill does not change that process at all. I have talked with those who have concerns about this legislation, and I'm attempting to address, or we have addressed at least one of those concerns through the amendment that we adopted today, limiting the statute of limitations for injury claims to 3 years from the date of death. Minnesota is not a litigious state. We receive high marks for fairness in our civil justice system. And in your packets, you'll see that claims in Minnesota actually are typically lower than claims in states that have caps. And I would also direct the committee to really look at the letters in your packets. They are really troubling and really highlight the really real need to pass the statute this year, or pass this bill. We have several people here who would like to share their stories with you, and then I'm happy to answer your questions. Thank you for your support.
All right, first on the list, I have Joel Carlson and then Chuck Slane. I've got a lot of testifiers to go through, so if everyone can stay focused, that would be great. Welcome to the committee. Please introduce yourself and go ahead.
Thank you, Madam Chair and members. Joel Carlson. I'm here on behalf of the Minnesota Association for Justice. I'm going to sound like Representative Moeller by the end of this week. It's about my 9th time in the chair this week. Very briefly, this issue first came to light for us when the very troubling instances of abuse in a care facility in Albert Lea came to light. 7 families sought justice in our court. All 7 of them dismissed because of this law, because they died from unrelated causes. We've been trying doggedly to pass this bill since 2013 to bring justice to these families. We have been working with those that have concerns, and we're going to continue to do that. But we believe this is the time to finally allow a full measure of justice for Minnesota families and consumers. And with that, we'll be here to answer questions. Thank you, Madam Chair.
All right, thank you. I have Chuck Slane, and then I have Heather Meyer on deck. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chairperson and committee members. My name is Chuck Slane, and I'm a lawyer in Minnesota and the president of the Minnesota Association of Justice. This law has been a priority for our organization and Minnesotans in general for years, because what happens now is that if an elderly or infirm person is injured in a crash or some other way, the strategy is to delay, defend, and hope for death. Because with death, the wrongdoer escapes accountability. Minnesota is the only state in the nation that allows this to occur. And it's time to change that. And we call on members of the committee to move this bill forward so that all Minnesotans can have access to justice. The last thing people want to do in their last days is fight in a courtroom to try and beat a clock to obtain justice. Give them the dignity they deserve. Thank you.
Thank you for your testimony. I have Heather Meyer and then Kay Brommelkamp on deck. And if I tell you you're on deck, that's your cue to move a little closer to the testifier table. Thank you. Please introduce yourself and proceed with your testimony.
Good morning. My name is Heather Meyer. My husband of 30 years, his name is Joel Meyer. We live in Nisswa. Joel is a veteran, having served in the U.S. Navy during the Vietnam conflict. 615 days ago, Joel underwent surgery to his colon and his liver as a result of a stage 4 cancer diagnosis in January of 2021. The cancer reoccurred in the spring of 2022, and it reoccurred again this past winter. He is not here today, and that is why. He just finished up another round of chemo a week ago today, and it has left him too debilitated to be here. And so I am here to share our story with you in the hope that it will prevent others from going through anything near what we have gone through. The sickness, the chemo, the doctor visits, and the constant fear and anxiety of what comes next have been hard. And it was made needlessly harder by a mistake that was made during surgery on July 9th of 2021. During surgery, the hospital staff and surgeons failed to account for all of the surgical sponges, despite the lead surgeon leaving a note in her report stating that all instrument and sponge counts were correct. They were not. A 12-inch by 12-inch sponge was left in his abdomen, and that is a sponge the size of a dish rag. I brought him home from Duluth on July 20th, and I called an ambulance on July 22nd. The sponge was discovered on the 23rd and removed on the 24th. In the 2-week period that it was in his abdomen, it created multiple infections and complications, and he remained hospitalized until fall. I brought him home on the 17th of September. During that time, he went from 199 pounds to 150. My husband is 6'3". He was delirious. He developed sepsis and nearly died. He couldn't keep food or anything else down, and he was depressed. He underwent surgery after surgery to insert drains in all of the infected abscesses the sponges left behind. His recovery lasted months and months, even after he came home. I had to feed him through a tube inserted in his belly 4 times a day, every 3 hours. I ran out of paid leave, and I subsequently ran out of money. To make matters worse, the hospital didn't seem to care. In a meeting initiated by them, they told me that they were sorry and offered me 2 $10 gas cards for the inconvenience of driving to the hospital 20 minutes from my home every single day from the 21st of July until the 17th of September. So we hired a lawyer. At the time, we didn't want to litigate, and we still don't. We are not litigious people. We have never sued anyone in our entire lives. We don't want to spend these valuable days of our lives sitting through depositions and needless paperwork. At this point, they are preparing to depose us the end of this month. We were hopeful that we could negotiate a fair settlement. We made them an offer, and they didn't even bother to respond to our offer. It was radio silence. As a result, we started a lawsuit. I'm not a lawyer, but I can read a pleading. And in their answer to our lawsuit, they denied any negligence at all and even stated that Joel may have been negligent and that he may have been the cause of his injuries. Keep in mind, he was in their care 24/7 from the 9th of July until the 17th of September, with the exception of one day, the 21st of July. They have now asked for a jury trial and even asked that we pay for their costs. A trial has been set for just after Thanksgiving, which should be our Christmas and holiday. And instead, we're going to be spending our time far from home in Duluth, trying to hold this hospital accountable. In my mind, there can only be one reason for the hospital to refuse to negotiate and to include ridiculous defenses and to ask for a jury trial, and that is that they are hoping that he will die from cancer before they can be held accountable for their negligence. They have all of his medical records. They know that he has stage 4 cancer, and they know that under current law, if he were to pass from cancer before we can hold them accountable, they don't have to pay a single penny for the harm that they cause. Please help us fix this terrible legal loophole that lets wrongdoers profit from the deaths of their victims. Thank you.
Thank you for your testimony. Kay Brommelkamp, and then I have Jackie Hennessy on deck. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair and committee members. My name is Kay Brommelkamp. I urge you to support House File 1019, critical legislation for our elder population. I'm a founding member of Elder Voice Advocates. Our members share experiences of abuse, neglect, pain, suffering, and injury and death of our loved ones in long-term care with no recourse under law for harm when their claims die with them. Under the current law, Minnesota statutes 573.01 and 02, justice for loved ones who are injured or die due to negligence is unattainable. The law operates as a disincentive for quality care. Pre-pandemic, my mother resided in York Gardens of Edina, assisted living for care related to her dementia and experienced ongoing neglect and abuse leading to her injury and death. She shared comments with us that we just assumed were related to her dementia, such as, "They're mean to me. I wasn't fed. I was hungry. I don't know how I got this bruise. There's a man that sleeps in my chair at the end of my bed." When we brought our concerns to the staff, we were repeatedly told that the care was checked off, therefore it was done. We had our own observations that led us to put in a camera. Unexplained bruises, unshowered at times, unchanged depends, safety sensors unplugged, finding our mom alone in her room while all the other residents were eating. Many mornings, we'd come and find her still in bed and none of her cares were given. In a 3-day span of time, from camera record, we observed night safety checks were skipped, no showers, no medications, skipped escort to meals. The morning aide would come in, lock the door, and go to the end of her bed in a chair and either sleep or watch TV. That was the man that my mom talked about.
If you could wrap up, please.
Okay. We also witnessed an aide, a different aide, dressing her roughly, stating, yes, she knows she's being rough with her, as my mom is so frustrating, and repeatedly hits our mom's leg, then yelled at her and called her a grown-ass adult multiple times. Our family would come most days to help protect our mother and care for her. On 3 different occasions, no cares were given for 16, 18, and 19 hours each. She lay in her own soil with no food, water, or depends changes. They knew about the camera. We reported the neglect and abuse of our mother to the Minnesota Department of Health while we waited for the state to investigate. Our mother suffered staff retaliation, the maltreatment continued, and she died. Based on our submission, the findings were substantiated maltreatment and neglect. However, the substantiation came too late, 5 months after her death. We later learned during the investigation that the facility had previously submitted their own report that falsely reported the severity of the abuse my mother endured. Even a small measure of accountability, the administrative process is extremely hard to achieve. Criminal claims are out of control of families and are extremely rare against care providers, even with egregious abuse and neglect. Families are left with a civil process only to find out the claims of horrific pain and suffering of their loved ones due to negligence leading to injury and death died with them.
I'm really sorry, but we, out of respect to the other
that's fine.
people that are testifying.
Thank you.
Okay, thank you so much.
House File 1019.
Jackie Hennessy, and then I have Toby Pearson on deck. Please introduce yourself and proceed.
Members, my name is Jackie Hennessy, and I'm here this morning on behalf of my family. My support of this bill is based on the tragedy of my family's experience and the belief that no family should have to repeat this. In June 2014, my mother, at the age of 79, was the victim of a witnessed sexual assault at the facility where she lived. The assault occurred at the hands of another resident who was not removed from the facility for another 6 days after our family secured an order for protection. In the following days, weeks, and months after the assault, our family engaged in multiple legal actions in an attempt to provide safety for my mother and to bring justice on her behalf. Initially, we were met with roadblocks, lack of support, which were explained away due to my mother's age, her cognitive status, and details of the assault. We finally connected with attorneys experienced with elder abuse who put into action claims on behalf of my mother, who continued to suffer emotionally from the sexual assault. The actions of our attorney to the responsible parties were met with delayed response or no response over months and months until my mother's death in 2016. Because this case was never brought to closure until in the courts of law during my mother's life, the case essentially died with her. She lived the last 2 years of her life suffering with a memory of the sexual assault and the fear that it could happen again. The negligence of the facility was never acknowledged. No one was held responsible. No one was held accountable. No authentic apology was ever given to my mother or my family.
And I'm going to have to ask you to wrap up. And we do have letters from both you and Ms. Brommelkamp in members' packets, so they can read those, as long as letters from other family members.
Okay, thank you. I ask you to support and vote in support of this bill so there's no incentive to drag these claims out, hoping the death of the victim closes a case rather than the justice of the courts. Thank you.
Thank you for your testimony. I have Toby Pearson, and then Aaron Hupert, and then Mary Krinke. Please introduce yourself and proceed.
Madam Chair, members, my name is Toby Pearson with Care Providers of Minnesota. On behalf of the Long-Term Care Imperative, I will be joined by Ms. Hupert for the second half of our testimony. First, I'd like to thank the proponents for taking the time to meet with us and explain their intent. We look forward to some ongoing conversations as we try to iron out some differences that still exist on the language. Unfortunately, our settings deal with death and dying almost every day. The process of dying is never easy. Our settings, and especially our hardworking staffs, have to deal with it every single day, especially during the past 2 years, in which many of us went through things with COVID. While we agree with the author and the proponents that this issue needs to be solved, we have not yet reached agreement with the language in its current form, even with the amendment. We still have concerns about the timing of the filing of the suits and the logistics of that timing. It's a complex issue. There are a lot of moving pieces within that, and we look forward to ongoing conversations with the author and the proponents and hope that we can find some language that we can all live with. Now I will turn it over to Ms. Hupert.
Ms. Hupert. Mary Krinke is on deck. All right, please reintroduce yourself and proceed with your testimony.
Sure. Thank you, Madam Chair, members of the committee. Again, for the record, Erin Hupert with Leading Age on behalf of the Long-Term Care Imperative. As my colleague mentioned, we conceptually do agree with Representative Feist and bill proponents that claims initiated before death should move forward, details to be worked out. However, we have concerns about extending the process to the length of time carried in the A1. I don't have the distinction of being a lawyer, so I will share with you what I shared in the Judiciary Committee of the other body. And that is, I had a very close and important family member pass away in 2020, May of 2020. They had been ill for some time, but it really took a turn around March of that year. So 3 years later, within the window of time that we're talking about with respect to the A1, there's a lot that I remember about those 3 years in very great detail. I remember we were trying to decide how often to see her, knowing that we didn't want to exacerbate or accelerate her decline. We knew very little about the virus in March of 2020. I remember when we got the call that she passed, and I remember when we had a graveside service that left out people important to her because we were limited to 10 or fewer at a service. I remember a lot about that time. What I don't remember or know was how much pain she was in on any given day during those final months. She received excellent and compassionate care. She passed peacefully on her own terms. But in an alternate universe, even under this bill with the adoption of the amendment, the committee would be asking a court to rely on me to attest not to what I could remember about my pain, but what I could remember about hers.
I'll have to ask you to wrap up. And just so folks know, all of the testifiers who signed up ahead of time were told they had 90 seconds. So please wrap up.
The organizations concerned with House File 1019 appreciate the intent behind the A1, but we remain opposed at that time for that 3 and 6 year timeline and look forward to resolving it with proponents. Thank you.
All right. Mary Krinke, please introduce yourself for the record and proceed with your testimony.
Madam Chair and members of the committee, for the record, my name is Mary Krinke, and I'm with the Minnesota Hospital Association. MHA is opposed to House File 1019 because it allows for the initiation of a cause of action on behalf of a decedent. Just like Ms. Hupert said, we are supportive of allowing claims that have already been initiated to continue. However, as broadly drafted, this bill is incredibly broad and would have significant impact to Minnesota doctors, nurses, and hospitals. Families of decedents can already recover for medical negligence and wrongful death, and there are certainly and sadly medical malpractice claims, as you probably heard about earlier today. That's different than what this bill does. The burden of defending care will fall on doctors and nurses, which is distressing and takes away time from patient care. The bill is written broader than other states that do have these survivorship claims, and many states have liability caps. There's a lack of clarity on who may be appointed as a trustee. It is concerning that this bill would potentially allow estranged family members to recover a claim from a decedent maybe the decedent didn't know or didn't want them to be able to file the claim. Medical malpractice insurance will cost more, and this is especially true for OBGYN practices that are having a hard time right now in Minnesota. We appreciate the opportunity to share these concerns, and I know a group has been meeting with Representative Feist on this issue, and like I said, we support claims that have already been filed to be able to continue. Thank you.
All right. Moving on to member discussion, Representative Niska.
Thank you, Madam Chair, and thank you, Representative Feist. And as I'm sure you all are well aware, a big focus of my work here at the legislature is trying to make sure that we're properly balancing our civil litigation system so that both we're really truly ensuring that those who are injured have meaningful remedies and that we're able to hold wrongdoers accountable, as well as not creating bad incentives for costly litigation that's really not remediating a particular injury or that's creating poor incentives or stick-up kind of structures in our litigation system. And so I know I sound like a broken record sometimes asking about the civil causes of action that we're creating. And this is, I think, a situation where it makes sense for us to calibrate the system a little bit differently in the other direction. And so I appreciate Representative Feist that you're bringing this bill forward. I don't think this is an area where Minnesota should be an outlier like it currently is on this particular question. And I also appreciate hearing that the way that you're working with and negotiating with other stakeholders on this. And so because I understand that you're continuing to do work on it, I am supporting it going forward at this point, and I'm happy to be a co-author on this legislation.
All right, Representative Feist, closing comments.
Yeah. Thank you, Madam Chair. This is the first bill presentation where I've almost cried listening to my testifiers.
You have a lot of bills, too.
I know, right? This is the first one where I've almost cried. So I think that we all heard the stories here today and understand the importance of this bill. And I urge everyone to support it. It's important.
All right. With that, Representative Feist renews the motion to recommend that House Bill 1019 as amended be placed on the general register. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Representative Feist, now we got House File 1859. Would you like to move to recommend that House File 1859 be referred to the State and Local Government Finance and Policy Committee?
Yes, Madam Chair, that is my motion.
All right, and then I understand you have an A4 amendment. Would you like to move that amendment and do that piece right now?
I would, Madam Chair. I also have an oral amendment to this amendment.
Okay, so Representative Feist moves the A4 amendment, and then please explain your oral amendment to the A4.
Thank you, Madam Chair. On line 1.3, after the word contractor, I would like to add or subcontractor. So it will now read to any contractor or subcontractor that is a signatory, et cetera, et cetera.
Okay. All those in favor of the oral amendment to the A4, please say aye.
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 Opposed? The motion prevails. The amendment is adopted. And now to the A4 as amended. Do you want to talk about the A4 now? Okay, go ahead, Representative Feist.
Thank you, Madam Chair. I just wanted to mention that this A4 amendment reflects ongoing conversations with stakeholders. We've broadened certain exemptions, and we've also, at the request of stakeholders, aligned language with Minnesota's Payment of Wages Act. So that is what this amendment is.
All right, all those in favor of the A4 as amended, please say aye.
Aye.
Aye. Opposed? The motion prevails. The amendment is adopted. Representative Feist, to your bill as amended.
Thank you, Madam Chair. Thank you, committee. So this bill addresses wage theft in the construction industry. 1 in 5 workers in Minnesota is likely to experience being misclassified, paid off the books, and/or having their wages stolen. These workers often don't even know who they are working for. 2019 law was a positive step in the right direction, but issues remain very prevalent in the construction industry in particular. Approximately 23% of the construction workforce is misclassified. Those workers are frequently paid entirely off the books by subcontractors that are often third-tier subcontractors or lower. This business model is this business model may not have been set up for the purpose of exploiting workers, but it is uniquely susceptible for profiting from the exploitation of a largely immigrant construction workforce for certain scopes of work. The exploitative business model is found in about 50% of multifamily construction projects under the drywall, wood framing, painting, roofing, and siding scopes of work. This bill provides a recourse to workers who have been victimized by wage theft. Contractors engaging in the subcontracting of labor on their construction projects are now liable under this bill for unpaid wages and damages stemming therefrom of the subcontractors performing work under their control. This bill applies to construction contractors and project owners if they are hiring multiple contractors who subcontract construction labor under their control. This will ensure that construction workers subjected to wage theft have recourse to collect unpaid wages from contractors, and it also incentivizes the hiring of responsible contractors by placing the responsibility to prevent wage theft on those who have the most control over construction labor practices. 8 other states have already passed similar laws. The bottom line is if you control the worksite, you can prevent wage theft. You have access to information on reputations and past actions of possible subcontractors. A subcontractor committing wage theft will have a bid about 30% lower than a legitimate subcontractor's bid would be. You choose the subcontractor for skills as a construction manager that you could hire and supervise directly, so it is a choice to subcontract at all. And this bill will provide more tools to enable general contractors to prevent wage theft by requiring that contractors are entitled to a variety of information about the payroll practices of their subcontractors so that they can prevent those subcontractors from violating the act and thereby prevent more violations of the act and avoiding liability altogether. This bill is designed to avoid unintended collateral consequences. It is a targeted bill focused on the construction industry alone and is further narrowed to really just address the specific types of construction project where this is a pervasive issue. And the amendment that we introduced today expanded the exemptions because we really do want to focus it on the areas that are problematic. The structure of this bill is not unique. General contractors assume workers' compensation liability and liability for OSHA violations and running a safe job site. They should also be responsible for subcontractors paying their workers in a lawful manner. This bill is well designed. The burden of avoiding wage theft should be on the person. Oh, now I'm losing my voice. It's contagious. I'm going to try that again. The burden should be on the person who has the most control rather than the one who has the least control. And I also just wanted to flag that this is about civil liability. It is not about criminal liability. So I don't want to conflate those two. I'm really proud to carry this really important bill that's going to protect vulnerable workers who currently do not have recourse. And with that, I will leave it to my testifiers.
All right, thank you, Representative Feist. I have Adam Dunnick and Bert Johnson. Mr. Dunnick, if you could introduce yourself and go ahead with your testimony.
Thank you, Madam Chair, and thank you, Representative Feist, for carrying this important bill. My name is Adam Dunnick. I'm the Director of Government Affairs for the North Central States Regional Council of Carpenters. It's a pleasure to be here this morning. In summary, House File 1859 will ensure that construction workers subjected to wage theft will have recourse to collect unpaid wages from contractors. General contractors and project owners will see the necessity to hire responsible subcontractors by placing that responsibility to prevent wage theft upon those with the most control over the construction labor practices. Compliance would finally be incentivized. And some may ask, why are we working on another wage theft related bill this session since one was just passed in 2019? Well, that's because wage theft remains a serious problem in the construction industry. National studies that were submitted via testimony from Matt Capice summarize some written comments that show a clear connection between workers who are misclassified and the cost to taxpayers. A 2021 study by the Midwest Economic Policy Institute estimates that 23% of workers have either been misclassified or paid cash under the table. And the cost of workers is an estimated $29,700 per year. And in Minnesota, taxpayers cost them well over $100 million per year annually. The Advocates for Human Rights, a well-respected immigrant rights and anti-trafficking organization, also recommended a 2016 comprehensive report curbing trafficking and exploitation in Minnesota workplaces that would amend wage and hour laws to ensure that companies that employ subcontractors and independent contractors cannot shield themselves from responsibility for the treatment of their workers. In some ways, it took a high-profile case of alleged wage theft for us to consider this legislation. The workers that we assisted who worked on the Viking Lakes project in Egan and across other projects in the Twin Cities were owed thousands of dollars over not just months, but years. The current law wasn't working for them. But it's not just about one general contractor or one developer. Unfortunately, there are many who are breaking the laws and benefiting from the status quo. And who is losing? The workers. And I want to thank the workers that have testified in previous committees. They've done an outstanding job stepping out of the shadows. If you didn't see that testimony, there's also a great story in the Star Tribune this weekend highlighting some of what they had to say. And I'll use their words. It's taking too long to get answers. We want support. We want justice. We believe that the best enforcement on wage theft and paying workers off the books is to have compliance. And the best way to ensure compliance is to have the general contractors be liable for the workers on their site getting paid. In the end here, our goal is not for a bunch of contractors to be caught breaking the law. Our goal is for general contractors to do the right thing. Hire subcontractors with real payrolls Real employees who are truly on the books, not cutting corners and paying cash under the table. This practice must stop. You have an ability to do that today by passing this bill and help a lot of working families, and I urge you to support House File 1859. Thank you, Madam Chair.
All right, thank you for your testimony. I have Bert Johnson, please introduce yourself and go ahead with your testimony.
Thank you, Chair Becker-Finn, and committee members for allowing me to speak today in support of House File 1859. My name is Bert Johnson. I'm General Counsel for the North Central States Regional Council of Carpenters. Been in that position for almost 17 years, and no issue has been more prevalent, risking the lives, the health, and well-being of not just the construction worker, but also the construction industry in Minnesota. I speak in favor of House File 1859 because it is specifically designed to protect workers by placing accountability for wage theft upon those in the best position to prevent it, the general contractor. First, and I won't go into detail on this in the interest of time, the construction industry has adopted a successful and profitable fraud model. Workers are frequently paid entirely off the books by subcontractors that are often third or fourth tier subcontractors or lower. Labor is subcontracted multiple times, ultimately to companies that we call labor brokers, who only exist to facilitate off-the-books payroll of an exploited, marginalized workforce. No withholdings, no work comp, no insurance, no taxes, no overtime. This is the norm for those workers. I refer the committee to the criminal prosecution of Ricardo Patrace and Leroy Meir, formerly of the ironically named Merritt Drywall. House File 1859 carefully responds to the established business model used to exploit construction workers by placing accountability where it belongs at the top. The wage theft responsibility bill before you cuts through the layers and makes upper tier contractors responsible for wage theft of subcontractors on their projects. It's an unfortunate necessity, but it is a necessity. The proposal before the committee is based on similar legislation recently enacted in New York. Liability for subcontractors, this is an important point for this committee, without requirement to prove knowledge or joint employer status is not a novel concept to contractors. Similar liability exists under federal and state prevailing wage laws and the Occupational Safety and Health Act's General Duty Clause. Minnesota's landmark 2019, as Adam said, wage theft prevention law gives workers in DLI new tools to fight wage theft. That is true, but it fell short in one respect. It left workers in DLI to pursue wage theft, but their recourse is directed toward those at the very bottom of a long and complex chain of subcontracting that's often designed for the very purpose of denying those workers their wages. Simply put, to prevent wage theft in the construction industry, accountability must start at the top. So today I want to address quickly 3 key criticisms of this bill that I think you'll hear. The first is denial of the problem of wage theft. I'll deal with this one shortly. Not only is this argument false, it is offensive to the marginalized workers who came forward at great risk to testify before other committees with their stories. Read the studies, listen to the workers, ignore the deniers. The second is the strange argument that general contractors somehow have no control over what happens after they subcontract labor. I would submit that this is not how they advertise and win work for customers. They're responsible for all aspects of a construction project, from the purchase of materials, equipment, scheduling of the work, securing skilled construction labor. Subcontracting is a choice and should not absolve the general contractor of responsibility for what happens to the labor after that point. General contractors compete and perform on their ability to manage and control these projects. This bill levels the playing field by ensuring accountability against competition on the basis of wage theft. The third argument is that House File 1859 is an aberration from the norms of construction and contract law. Well, this isn't a construction or contract law bill. This is a labor bill. This is the norm. By statute and judicial interpretation, there are many examples of worker protections that impute liability or otherwise impact subcontracting of labor. Unquestionably, the legislature has the power to regulate an industry like construction where subcontracting and misclassification are prevalent and where is well documented as in the construction industry, it is imperative to do so. This bill is needed now more than ever. This is a labor bill. It is a worker bill. With this bill, you have an opportunity to make a big difference in the lives of construction workers, especially the most marginalized workers around this state. I urge you to support House File 1859, and I appreciate the opportunity to testify.
Thank you for your testimony. I have Laura Ziegler and then Peter Coyle on deck. Please introduce yourself and proceed.
Good morning, Madam Chair, members of the committee. My name is Laura Ziegler with Associated General Contractors of Minnesota. We represent over 350 commercial general contractors, subcontractors, and suppliers. Additionally, over 80% of our membership are union affiliated and signed to a collective bargaining agreement. I will begin by saying AGC of Minnesota unequivocally condemns and does not condone the practice of wage theft, and that's full stop. Our position on House File 1856 is that the legislation is misguided, and we are concerned about some unintended consequences. We say misguided because it does place that legal responsibility for the criminal act of wage theft on the upstream contractor that does not control or lacks complicity with the illegal actions involving wage theft. And furthermore, it provides no path for that upstream contractor to effectively manage the risk imposed by those downstream subs. And it does that by invalidating the contractual indemnification for claims for payment by workers, which is a very common provision because it works. It's used as a mechanism to make sure that the payments flow down to the subs and their workers. So under this bill, a general contractor or an upstream contractor could do everything right, make the payment to the sub, and then has to pay again if there's a claim from a subcontractor, for example. We talk a lot about generals having control over the job site. Job site safety is very different than evaluating payroll records and the books of subs. So there is a distinct difference. And in closing, Madam Chair, I do want to point out another unintended consequences we have talked about is this could affect our partners, especially those subcontractors who are minority-owned, women-owned, if they're required to do additional administrative tasks associated with submitting the paperwork, requirement of payment bonds, which they cannot get. I just want to make sure we're on the record with that concern. So thank you very much.
Closing sentence. And for the other lobbyists and public testifiers, when we say 90 seconds, we mean prep for 90 seconds. Mr. Coyle, and then I've got John Beshy on deck. If John Beshy could come take a seat over here so you're ready to go right away. Mr. Coyle, please introduce yourself and proceed with your testimony.
Madam Chair, members of the committee, my name is Peter Coyle. I'm Legislative Counsel of the Housing First Minnesota. Thank you for the opportunity to testify. Housing First Minnesota is the largest trade association dedicated to the home construction industry. I'll start by saying we do not condone in any way wage theft, as it's been alleged to occur. I've heard the testimony, and I take it to be serious and respect the views of the employees who share their testimony with the committee. But the bill as presented to you is a sledgehammer to a problem that is, in our opinion, relatively isolated to several bad actors, as have been identified in the record. The bill forces liability onto general contractors who have no legal responsibility for the work of subs of subs. They're not involved in hiring, they're not involved in payment, they're not involved in the day-to-day work effort of those employees on the job. But this bill would force the general contractor to take on that responsibility. The dire consequence of that is it's going to limit the opportunity for subs to break into the industry, because the generals are going to have to be much more selective on who they bring into a job site based on their longstanding business opportunity and relationship. And I think that's an unintended negative consequence of the bill. Finally, this bill will impose significantly higher costs on home construction. And as we know in Minnesota, housing costs are out of control for a variety of factors, and adding one more regulatory cost to the cost of a home will make it that much more difficult for wannabe home buyers to enter the housing market. Thank you, Madam Chair. I appreciate the time to speak today.
Thank you. John Beshy and then Brooke Bordson on deck. Please introduce yourself and proceed.
Thank you, Madam Chair, members of the committee. Again, my name is John Beshy with Associated Builders and Contractors of Minnesota. ABC is fundamentally opposed to the idea that general contractors should be required to assume the liability for unpaid wage and benefit claims that are brought by subcontractors. This bill paints all general contractors with a broad stroke by implying that they are bad actors who are engaged in intentional efforts to commit wage theft. This assumption of liability is unfair to contractors who have no knowledge of what may have transpired between subcontractors and their employees. employees. The general contractor does not sit on the HR or accounting divisions of the dozens and dozens of subcontractors that they work with on every single project. This bill requires no showing of intent to impose this liability, so the ultimate effect will be to punish innocent parties for the alleged bad actions of others. We also find it interesting that this approach seems to only apply to merit shop general contractors, as the bill explicitly permits the assumption of liability to be waived by a collective bargaining agreement with the trade union, but provides all other general contractors with no similar ability to transfer this liability. And we think that is an extremely uneven playing field. This bill also creates an explicit carve-out for prevailing wage projects. The Star Tribune article that was referenced earlier spoke about the first criminal charges against an employer for wage theft, which was a project that paid prevailing wage. I will wrap up because I know time is of the essence, but rather than create an unfair system where liability flows upstream regardless of knowledge or intent, we would like to see the Department of Labor and Attorney General enforce the wage theft laws on the books. In closing, we urge the committee to vote no on this bill. Thank you again for the opportunity to testify.
All right, Brooke Boardson, please introduce yourself and proceed with your testimony.
Thank you, Chair Beckerfin and members. My name is Brooke Boardson. I'm with the League of Minnesota Cities, which represents 837 cities across the state. I just wanted to briefly touch on a concern from cities about the bill. Under the new definitions in the bill, starting on line 3.25, a city as a project owner could be deemed a contractor in certain circumstances and liable for all claims as such. Because public projects are funded with taxpayer dollars, municipalities as project owners are subject to unique requirements under the state's Chapter 471 Uniform Municipal Contracting Law and other statutes. These requirements include a sealed bidding process and acceptance of lowest responsible bid, obtaining performance and payment bonds for certain public projects. 574.26 requires projects over $175,000 to include a payment bond. For projects where a payment bond has been obtained, subcontractors and workers can make a claim against the bond for wages that they're owed. We would request that language be added to the bill stating that these new provisions would not supersede recourse under the payment bond when a city has required a contract owner to provide a payment bond. The intent of this would be to clarify how claims would be reconciled. And I just want to thank Representative Feist for continuing to discuss our concerns and stakeholders as well, and happy to work with folks going forward. Thank you.
All right, thank you for your testimony. We do have an amendment. Representative Niska, would you like to move A2 amendment?
Thank you, Madam Chair. Yes, the A2 amendment is a different enforcement mechanism, particularly calibrated, I think, towards residential contractors who already pay into a contractor recovery fund every year, which is a way that it's administered by the Department of Labor and Industry as a way to deal with the situation in which a contractor goes belly up or a subcontractor goes belly up. And so that strikes me as a more efficient, quicker way to help harmed workers, and in the particular case of a residential contractor, maybe a more fair way to deal with a general contractor who's doesn't have the ability to audit their subcontractors' employment records necessarily, and who's already paid once for the labor. It does create a mechanism for the department to then pursue a subrogation claim against whoever was wrongfully, whoever was responsible for the non-payment of wages. So I move the A2 amendment. Thank you.
All right. Any response to Representative Feist?
Yep. Thank you, Madam Chair. It's an interesting idea. I would ask the committee to vote no at this time because most of the projects that we're talking about under this bill would be exempted from being able to even assert claims under 326B89. In addition, they have a payout cap of $75,000, which is really problematic because for bigger wage theft cases, they would exceed this and have no recourse. It also only has 9.5 million right now, and so if there were a lot of claims, that would easily be wiped out pretty quickly. So I think for those reasons, I don't think this is an immediate option for how we would structure this bill. I think we'd have to make changes to that fund for it to be workable in this context. Thanks.
All right, Representative Niska, closing comments on your amendment.
Thank you, Madam Chair. I think, again, this is very specifically about residential contractors and residential subcontractors, and the fund has $9.5 million in it because it's essentially overfunded currently for the liabilities that were created. So I think in this context, it actually is an appropriate amount of money and appropriately targeted remedy. So I do hope, Representative Feist, we can continue to talk about it. Thank you.
All right, all those in favor of the A2 amendment, please say aye.
Aye.
Opposed?
No.
No. The motion does not prevail. Any further discussion to the underlying bill? Closing comments, Representative Feist.
No discussion? I was ready to talk. Well, I think this bill is very important. I've been working a lot with stakeholders who've expressed concerns because I do want this to be a workable bill where liability is really clear to general contractors. You know, as we've said, the construction industry, I don't think that I wouldn't go so far as to say that like the structure of general contractors and subcontractors is set up for the purposes of fraud, but it is really uniquely susceptible to it. And so this is a way to address that, and conversations continue because I want it to be a really good bill. So I would urge support. Thank you.
All right, Representative Feist renews the motion to recommend that House File 1859 as amended be referred to the State and Local Government Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed? No. The motion prevails, and we're sending you to State Gov. Members, if you can make sure that you put the bills we didn't get to back in your folders, that will save our committee staff time. And with that, we are in recess.